Muy buenos días a todos ustedes. En nombre de la International Chamber of Commerce México, les damos la más cordial bienvenida a nuestra sesión remota del Comité de Arbitraje Jalisco. Les recordamos que nuestras reuniones se rigen bajo el protocolo de competencia económica que se encuentra integrada en nuestra convocatoria. Con respecto a esta sesión, les recuerdo que hemos enviado algunas recomendaciones, por lo que les pedimos, por favor, mantener su micrófono en silencio. Al finalizar las exposiciones, tendremos oportunidad de recibir sus preguntas, para lo cual les pedimos, por favor, levantar la mano en su aplicación o solicitar el chat de la plataforma para que les podamos dar la palabra. Sin más, damos inicio a nuestra sesión, para la cual le cedo la palabra al maestro Gustavo Morante Aguirre, presidente del Comité de Arbitraje Jalisco de ICC México. Adelante, Gustavo.
Gracias, Laura. Good morning to all and welcome to another session of the Jalisco's Committee of Arbitration of ICC Mexico. First of all, I would like to thank the participation of Don Alejandro Ogarrio, Chairman of the National Commission on Arbitration and IDR of ICC Mexico, who kindly accepted to share a message with us. The floor is yours, Don Alejandro.
Thank you very much, Gustavo. It is really a pleasure to be with the Jalisco Arbitration Committee of ICC Mexico. I have to congratulate you once again for having put this incredible session, in which we have Angie Raymond, United States, in which we have Rodrigo Acevedo from Brazil, and Natalia Gulayeva from Moscow. And not only they are from those places, but they are physically in those places. So another example of how technology is allowing us to benefit from this terrible pandemic, which is really putting the world in bad shape. But at least for arbitration and for the arbitral community and for schools and this type of practice is working fine. And this actually takes us to the topic of this session, because it has to do precisely with intellectual property arbitration. And we have known, what is commercial arbitration, investor arbitration. We speak a lot about energy arbitration, oil and gas, but IP arbitration is something that is taking a place in the world as a specialty. We have just spoken of technology, and obviously there are many issues concerning technology, research and development that have to do with problems which arise. Not everything is solution, but obviously there have to be some problems. And that's where IP arbitration and the WIPO may come into place. We all live with internet. This is an internet session. I mean, who is better equipped to deal with internet problem, with abuse registration of internet domain names than WIPO? And that's all that we're going to hear today. It is a tremendously interesting world of arbitration. For us who have been dedicated to this specialty for some years, it begins with the arbitration clause. And I'm sure that they will tell us what is the difference between an IP arbitration clause and what we know as a normal, let's say, commercial or investment state arbitration clause or entrance and key to the process. So we're very much interested. Let us not forget about patents, trademarks, patents infringements, how all this comes into place with the IP arbitration. It is a very, very interesting specialty, and we are so happy to hear from you. I will repeat the name of our three guests. I'm very happy also to mention that this is the third day of what we have named Mexican Arbitration Week, in which the Commission in Mexico City, the committees of Nuevo León, Jalisco, and Bajío are holding on 4 consecutive days sessions of arbitration in order to enlighten ourselves with the aid of people as brilliant as our guest, but we are in a course of delivering the message of the benefits of arbitration in Mexico. We're all convinced, but there are a lot of people who are joining us and who will be new to this world of arbitration, and now especially of IP arbitration. I think that I don't want to take the time of our distinguished guests, and I would like to turn the floor to Gustavo for their introduction. And again, thanking you for the effort, because even though, as Angie mentioned, she's in the United States and she will be somewhere else and be assumed later on, it is always a big effort to prepare for a session like this and to share their knowledge and comments with us. Thank you very much, and please go ahead with your interesting session.
Thank you, Don Alejandro. As you were saying before we open the session, this is a miracle of Zoom to make the distance irrelevant. I now would like to congratulate my friend Agustin Vargas for successfully organizing this session and inviting our international speakers of today, with whom we are sincerely grateful and honored for being with us. I ask Agustin to take the floor for introducing our guests.
Well, I first say thank you, Gustavo, Don Alejandro, Don Carlos, everyone that make the time to be here with us. And I really want to be thankful with Angie, because she was my first contact. And if this is actually happening, is because she make it possible. She was really open to hear me out, to let me express the intention of having this kind of session here. And she was really open to help us out. And now we can get this session as interesting as it is, with people from 3 different perspectives, all in international intellectual property, but also with the view and the particularities of alternative disputes, like arbitration. So I also am seeing that Margarita, the former minister, is with us. So Gustavo, I'm sure we want to welcome her before I jump again to give the names of our speakers. Presentation.
Thank you. Well, we are really honored to have here the former Justice of the Mexican Supreme Court, Doña Margarita Luna Ramos. Thank you for being with us. And thank you, Agustin.
Okay. Ms. Margarita, really welcome and honored that you are here with us. So, Angie Raymond is the director of the program on data management and information governance at the Ostrom Workshop. Is an associate of professor in the Department of Business Law and Ethics at the Kelley School of Business, Indiana University, and an adjunct associate professor of law at Maurer Law School in Indiana. Rodrigo Acevedo is one of the pioneers in protecting Brazilian companies in digital media. Rodrigo is the head of IP and digital law at Silverio Advogados. He also acts as head chair, arbitrator, and mediator of the World International Property Organization. Welcome, Rodrigo. And Natalia Gulaeva is managing partner, head of global regularity and IP media and technology practice group, head of life science industry group in Hogan Lovells CIS in Moscow. Natalia, Rodrigo, Angie, thank you very much for being with us. And this is your floor, and we are very eager to hear from you. So I will pass the order to Gustavo, just to make sure that we are all set and we can give the floor to Angie for stars.
Yes, we're ready. Please, Angie, take the floor. Thank you very much.
Thank you, everyone. What a wonderful welcome. And thank you for inviting us as well. This is for those of you who maybe have taken the WIPO arbitration course. This is your group of instructors. We're missing one who couldn't make it, but in general, this is your group of instructors. And for some of you, it's the first time you've actually seen our faces. So that's how this contact occurred. And I can speak for all of us and say we're very appreciative to be invited and look forward to this. If you can share the slides for me.
Laura, now we can share the slides.
Yes. And then we're going to go to the table of contents is where, because we've done the intros. And if you want, these slides can be available to you. And of course, it looks like there's a recording happening as well. So you're welcome to reach out to us as well. We are individuals who do this for WIPO and other organizations. So we're very accustomed to having people reach out to us. So do feel free to do that as well. So this is the contents of what we're going to go over today. And obviously we as a panel really want to get to questions and answers. When we get this opportunity, we like to frame the conversation a little bit and give you a little bit of background, but then for the most part, we hope to answer whatever questions you have. That's especially true for those of you who are new or newer to arbitration or new or newer to IP types of arbitration, because we like to, and we're very appreciative of the opportunity to promote arbitration as a very valuable alternative to court systems, especially when you're talking about cross-border environments. So my task is to talk about just the basics of what is arbitration, and then I'm going to hand it off to Rodrigo. So what is arbitration? Well, for those of you who aren't familiar with arbitration, and I promise not to spend a lot of time on that because I do assume everyone on this call is somewhat oriented to it. But in general, arbitration is an alternative to the traditional process that you might be familiar with in domestic courts. In the international community, it's very at times frustrating, but also very difficult to go to a local court and have a dispute heard. It's not impossible, but it does require you to meet all the requirements of the domestic court system. There actually are very few international courts, however you think through that, and I really don't want to do a jurisprudence class. But it's important that you understand that there's, despite the fact that we sometimes call the ICJ the world court and things like this, just doesn't exist. So arbitration for a lot of businesses in today's global world is really the best source of resolving disputes. Now, the way that happens is pretty simple, actually. Arbitration is widely recognized around the world as appropriate alternative to the court systems. And as such, through an international convention called the New York Convention, all countries in general that you would be interacting with, some exceptions, have signed the New York Convention and have agreed to have a formal process recognized and creating an outcome that is enforceable in a global environment. So I'm going to talk about those couple of things in detail. First of all, arbitration is touted as something that we want to use because the outcomes and the process itself are confidential. And the way that we create that confidential process is through the contract itself. So the contract that governs the parties' relationship in general will contain an arbitration clause. What that means is, if you're not familiar with arbitration at all, most of these actually all of the international arbitration institutions have a standard cut and paste arbitration clause that you can put into your contracts. There's all kinds of positive reasons to do that, but I'll leave that aside. What that means is the biggest decision for you is to find an arbitration institution that matches and best supports the type of dispute that you anticipate occurring. And so in our opinion, and I think the panel will share this opinion widely, the best place to resolve an IP dispute is probably at WIPO. So if you wanted to have the WIPO system support your arbitration, support your dispute resolution process, what you would do is Google, quite honestly, WIPO arbitration, and up will pop the rules. And all you do is cut and paste the arbitration clause, put it in your contract, and you'll go to arbitration. It's that simple. When you incorporate that clause into your contract, WIPO institution will support you. And what I mean by that is, if you're in an alternative to the court systems, the court support doesn't exist for you. So simple things like, where do I file my submission? Where do I make a complaint? How will I select my decision makers? All of that comes from institutional rules. And by incorporating the WIPO arbitration clause into the contract, you get the institutional support and the procedural rules that allow you to proceed with your dispute. One of the important aspects of WIPO is confidentiality, which in IP context is incredibly important. Now, the other thing that's really important, in my opinion, is oftentimes arbitration, depending on what system you're talking about, is oftentimes remarkably quicker process than the traditional courts. And that is, a matter for another day. We can talk about whether or not that's a good or bad thing, but arbitration allows you to also have a more traditional process, but you can also do what's called an expedited process, which means it happens much quicker and the timeframes are much quicker as well. So the key to the arbitration in general is to really, at the time of contracting, think about, in my opinion, what dispute you think you'll have to resolve and find the right institution to resolve that dispute. And there are a lot of them to select from. But once you've made that decision, you incorporate the arbitration clause into your contract, and then you pay, of course, but you pay the institution to provide you all that support that you normally would get through the court. Where do I file? What are the filing fees? How do I know, who's going to resolve my dispute? All of those decisions. Now, the last thing that arbitration brings us that is so important, especially for those of you on here who have clients who have truly an international global reach, is the enforcement of the outcome. And it doesn't matter what context I'm talking in. When we're talking about law, it needs teeth. There needs to be a way to monitor and enforce individuals' behavior to encourage them to behave in a socially acceptable, compliant manner. That's done through enforcement. So arbitration awards are enforced in your local domestic courts, even though it arises from an international related dispute via what's called the New York Convention. And the New York Convention is pretty simple in its requirements. It requires nothing more than an arbitration agreement that's signed in writing. And in today's electronic world, most states recognize an email or an electronic signature, not all, but most. And the basic protections of due process have to have occurred. You have to have notice, you have to have an opportunity to present your case, those type of things. A neutral decision maker, those type of things, really basic notions of due process. And as long as that occurs, the outcome that you receive is called an arbitration award, and that award, in the most simplistic of explanation, can be converted to a domestic award that can be enforced in domestic courts around the world. Now, that's a little overly simplistic. It's not really a conversion, but do understand that's the idea. You walk in with an international award to the local courts where you want to seize a bank account, where you want to seize an asset to recover whatever amount is that they owe you. You walk in, you give them a copy of the arbitration agreement, you give them a copy of the outcome, and they then follow their local process to begin the enforcement of it. So there are very, very few international decisions that receive that level of respect and reciprocity. It's that simple. So arbitration awards, between confidentiality, the simplicity of creating arbitration as an alternative to you, and the enforcement of the outcome, that just makes arbitration in general one of the most positive, best choices, in my opinion, for most international businesses. And that's especially true when you talk about intellectual property, because you have this amazing institution known as WIPO, which Rodrigo is going to speak about.
Good morning. First of all, I'd like to express my pleasure to be with you. Unfortunately, not physically, which would be an even extra pleasure to be in Mexico, especially for a Brazilian. I really love your country, have many friends there. but at least technologically using Zoom. Yeah, this is what we are using nowadays to perform our work and to be in contact with friends. And and here we are talking about arbitration. Let's talk a little bit about WIPO. So the World Intellectual Property Organization is an independent intergovernmental organization that was established in 1967, I believe, through a convention in Stockholm. The WIPO is part of the United Nations systems of organizations and is headquartered in Geneva. The main goals of the WIPO is, first of all, to promote the protection of intellectual property worldwide. It's done through collaboration between states and sometimes with collaboration with other international organizations as well. But this is done especially in order to try to promote innovation and creativity. At WIPO, we believe that a robust and dynamic intellectual property system may encourage this innovation, these technological improvements that are very beneficial for the countries. Some of the activities that WIPO performs are, first of all, to administer some very important treaties in the field of intellectual property. I could mention, for example, the Paris Convention for the industrial property, the Berne Convention that is focused in the protection of literary and artistic works in copyright, in many other conventions and treaties such as the Madrid Treaty and Protocol, etc. But also WIPO has a specific center to host disputes that are alternatives to the traditional judicial procedure. Those disputes are managed by the WIPO Arbitration and Mediation Center, which is also in Geneva. There are also some, they have also some presence in Singapore and in other countries. The center, the Arbitration Mediation Center, was established in 1994, and it tried to provide alternatives to litigation for resolution of, especially for commercial disputes involving intellectual property. It's not only for intellectual property, but as an organization that is pretty much focused in this field of practice, it rapidly established itself as the main specialized center for hosting disputes in this specific field. Nowadays, WIPO has the Arbitration Center rules for mediation proceedings, for arbitration proceedings, as Engi already referred, for a kind of expedited arbitration proceeding, which is even faster and simpler than the regular arbitration. Some expert determination rules, and WIPO is probably the main provider for the UDRP. The UDRP, for those that are not used with domain names, is the Uniform Dispute Resolution, Domain Name Dispute Resolution Policy, a kind of very informal, very simple proceeding to manage disputes with domain names, with online disputes concerning to domain names. This is WIPO. Engi.
Natalia?
So, sorry, just a quick interruption, just to mention to the audience, if they would like to ask some questions, please, in the chat, send just your name or your point that you would like to express some questions, or raise your hand so we can keep control and then give you the floor for ask any of your questions. Thank you very much. Sorry for the interruption.
It's not a problem. And next issue which we wanted to cover in this introductory part of the seminar is what is actually different for IP in arbitration. And as it has been already touched by Alejandro in the beginning, indeed these days we have a lot of disputes arising out of technology matters, data disputes, technology disputes, also mentioned domain name disputes. All that, of course, is very, very specific and requires knowledge and intellectual property law and understanding, which is necessary for all the participants, for the arbitrators who would consider the case and hear the case on the merits, for the experts to be involved into the proceedings, and of course to the counsels to the parties who would participate in the proceedings and represent the claimant and the respondent. So all this is very, very relevant. And of course, everyone wants to have a great IP arbitrator, a great IP expert, and great IP counsel to represent the party. However, here, the slight difference is that nowadays the number of the specialists in intellectual property is much more limited than those who deal with commercial arbitration. And the answer to this is very, very easy. Why it's happened? Some time ago, I was going through the figures, through the statistics of the Russian state commercial courts and comparing them, what number of disputes we have for each area. And we have in Russia a system of state commercial courts, which are 85 in the whole Russia. And so by a calculation, I understand that for every court, there are approximately no more than 100 disputes a year for example, for license agreements. And to the contrary, there are more than 2,500 disputes per court for sale and purchase agreements. Therefore, as you may understand, it's simply IP disputes. They are becoming more frequent, but it's limited amount. Therefore, less experts, less specialists. And of course, for the parties in IP arbitration, or for those who consider IP arbitration for them, this is a major task in the beginning and before the proceedings to find these specialists who will be able to consider the case properly. And of course, if you get a great IP arbitrator with the experience in IP matters, then you are in good hands. And to give you example why, because it doesn't matter now we speak about the proceedings before WIPO or any other institution. If you have an arbitrator who had experience in IP laws or as professor in IP laws, and who knows precisely what the parties mean when they negotiate a license agreement, for example, a patent license or patent and technology license, for every definition of this contract, what is behind each word, what each provision actually means, foreground IP, background IP, how the royalty are constructed, how the payments under license agreements, what is usual for the industry, what is unusual for the industry, etc., etc. All these issues, which may be an absolute terra incognita for a judge from the state court, because he has never dealt with this, will be very, very clear for the IP specialist who is handling IP arbitration. And of course, if you have a multi-million or even multi-billion technology dispute, it's very important that the one who is deciding on whether you are right or wrong, or your client is right or wrong, it's very, very important that he has or she has this background. So I value deeply the expertise of WIPO and WIPO Arbitration and Mediation Center. And of course, since we have the ICC as the organizer of this event today, I may also mention that for example, I have participated many years ago in the ICC Advanced Arbitration Academy for Central and Eastern Europe. And that was also like the WIPO course where Angie, Rodrigo, and I act as tutors. ICC Academy has given me a lot because there it's a slightly different mode and slightly different task. You are being taught to act as arbitrator. You are being explained what is expected from you as arbitrator, how you act, what you do, what is most important, what is an absolute focus of your job as arbitrator, etc. Therefore, I think every international institution does contribute to international RP arbitration immensely. So what to add? What is different? Of course, there are different contracts than those which you see in IP arbitration, in commercial arbitration, where you would usually, for example, look at international sale and purchase contracts or others. For intellectual property, very often you have research and development agreements, R&D agreements, you see license agreements, you have to deal with franchise agreements, all these specific, very, very special stuff. And as I said, it's important that the one who deals with that understands what it is about. So I'm conscious of time, and I think the important point to make is also that it's simply, as said by my colleagues, it's a different world, but there are specialists, and there are specialists who will be able to help. And of course, three of us are very happy to help and very happy to answer later also your questions. And my 10 minutes are over, and we are moving to next subject.
I see we have a couple of hands raised. So we have a couple questions prepared in case nobody asked any questions, but we have a couple questions. So maybe before we move on, we should hear the questions that have already arisen.
I raised my hand because there was an obvious question that Natalia, I think, saw that it was coming. I think that you did a great job because you were preaching to the converted. I think that we are all in favor of arbitration. We know what it is. We've used it extensively. And as Natalia mentioned, you know, we are part of the ICC in Mexico organization. And the question would be, what would be the advantage in an IP arbitration to use a WIPO clause rather than an ICC clause? Because as we have always said in arbitration, what matters in order to have a good arbitration is the arbitrator, and the arbitrator. And obviously, whoever is going to have an arbitration in an IP matter is going to choose an arbitrator who has expertise in the subject matter. Otherwise, it would be absolutely not understandable. But as far as the management of the arbitration is concerned, we have several institutions that manage arbitrations, And now you have mentioned that WIPO does that kind of thing. It is obvious that the expertise of WIPO in domain name resolutions has been established. They are, I would say, the only one who carries that kind of dispute resolution. But when it comes to other, technology, research and development, even internet and what have you, what would be the difference? I can assume that WIPO, I don't know if they provide the names of arbitrators through a list mechanism, such as some other institutions do. I don't know if they have a list of experts, which can be provided by WIPO in case, an arbitrator who is taking care of a particular situation asks for expert assistance. So I would be very much interested. I know that, as Natalia mentioned, you have taken the course of ICC, and what would be the difference between going into an arbitration, which is a normal commercial arbitration, and what you would call a WIPO arbitration?
So Angie, do you want to start?
Yeah, Natalia, why don't you start with that and then we can jump in.
Of course. So clearly, not every institution, international arbitration institution, has a list of arbitrator with particular focus in intellectual property. And this is what I think differs WIPO from many other international arbitration institutions. Of course, this is tremendous difference where you can have a list of those who are already included. And I don't see it as restrictive because those who are included, they're being tested regularly in these disputes. They know well their stuff, and this is convenient, at least for the clients, to choose from the list. Second point, but Alejandro, you have already covered that basically very, very well, and Rodrigo mentioned that in detail. Of course, the man name disputes, because you can handle get the matter handled for a very reasonable amount of money during a very short time period, and you get your award and it's done. Of course, also here, there are problems with the countries who do not have UDRP proceedings established locally and who do not recognize automatically the awards issued in domain name disputes by WIPO. And here, the opponents have possibility to ruin what has happened before WIPO by initiating the national court proceedings. Unfortunately, for example, Russia, it's the country where for .ru and .rf disputes, you have to go to the national courts. You cannot go to WIPO. But if there is a .com dispute, you're free to go to WIPO. Angie, Rodrigo, your points on this?
I would just like to add that there are some collaborations that WIPO have nowadays and is always improving, even with patent and trademark offices that sometimes creates an environment in which the dispute inserts itself in the proceedings. In Brazil, for example, some years ago, we had a collaboration between our patent and trademark office with WIPO in order to provide mediation during the trademark applications when someone opposes to a trademark application. And it was done through a collaboration with WIPO, creating a specific proceeding for this goal. There are some collaborations with many other countries. In Singapore, for example, there are also some initiatives like that. But I agree with you that WIPO is not the only arbitration mediation center that can provide specialists in intellectual property. You can use even as an expert in order to help you understanding the technical issues during other proceedings under different chambers, arbitration chambers. But WIPO is really focused in this topic. It was built focusing in intellectual property. It lives intellectual property from 24 hours per day. And all the experts that are part of the WIPO list are intellectual property specialists. Many of them has a long experience as professors in this field, or are domain name specialists, panelists that have been deciding cases for many years. The number of cases of intellectual property arbitrations is not that high worldwide, not only at WIPO, but last year I gave a speech in Miami in arbitration technology event, and I looked for numbers on arbitration within IP topics. And what I figure out is that worldwide, there are many cases, many cases, more and more, in which intellectual property is part of the discussion, but not always is the only and central issue. So it is still it's a field that is still to be developed. The communities, the IP community and the arbitration community sometimes are separate teams. The events are not the same. And I think participating today here is also a step in order to get together and to find how to ways to promote more and more the use of alternatives in this field more and more.
I have one quick comment, and then let's take the other hand, I think. But the one thing I'll add is that my primary start to teaching it all was in international commercial law in general. And I think it's a fundamental decision what institution you use, because it not only gives you access to particular groups, but it's a way to manage risk. And I don't mean to be that blunt. I mean, you heard early on that, my primary appointment's actually at a business school. So I spend tons of time teaching students how to think about how to manage risk. And part of the risk is looking at your total relationship and thinking, hold on, is IP a part? Or is IP the essential or the only? And then finding the right institution. That's risk management that I am of the opinion we need to get much better at in general as lawyers, explaining to our clients. And so, and that's not a minor choice. But I also mentioned that I started with international commercial law because, one, I'm a contracts focused person, but also when someone invites me to speak at the ICC, this is like my dream institution. Between the Incoterms, I mean, just think of all the stuff that you all have done. So it is a fundamental choice which institution you go with, and it might at times come down to something as simple as which institution you're most comfortable with. And that's not that's not something that I would widely, publish in a book. Hey, whatever you feel comfortable with your buddies at the ICC, not WIPO. But it should be part of how you're thinking this through. And so, for many of you, the ICC is the institution that you're most comfortable with. And unless you really need IP to be the essential focus of a conversation in terms of issue resolution, the ICC is, again, I mean, it didn't even cross my mind to say no. The opportunity to be in a conversation with a group of people connected to the ICC for an international commercial lawyer is, I can't think of an institution that is more influential on who I am. So that's what we're trying, we're trying to show you a little bit of a different side, but understand, this is about risk mitigation as far as I'm concerned. And it is about mitigating the risk for your business by identifying what issue you think will be the predominant potential dispute, and then being in an institution that will support the resolution of that issue, and think about comfort.
Let me just,
jump in. This is an interesting conversation, so let's.
You can give me the answer in 15 seconds. If you have an ICC clause and you're looking for an expert in IP as an arbitrator, would it be possible to go to the WIPO and say, give me a list of possible arbitrators who are experts in internet or whatever? Would that be possible, or is that possible?
That's a good question. I've never, so first of all, it's, I don't know anyone who wouldn't have it on their sort of their LinkedIn profile or their CV. So that would be the first thing to say. I've never tried. Have either of you actually, just from an external point of view, tried to ask WIPO if they would give us a recommendation? I've never asked, quite honestly. So I guess that opens it to the floor. I would assume the answer is yes. If you include an ICC clause and your intention is to then, when appoint an arbitrator that is knowledgeable in the dispute area once it arises, I don't know WIPO would give you the list, but it's not secret. Most of us, share what we do. So, but I don't know. Rodrigo or Natalia, have you ever asked WIPO for a recommendation like that?
I haven't asked, but many lists, they are actually open.
Yeah.
And for example, if Alejandro, you go for Hong Kong International Arbitration Center, you can see the list of IP arbitrators. Same, for example, for a Russian Arbitration Center, you will find the list. And for WIPO, I know that, of course, you can navigate for demand dispute resolution who has issued the award, and you can understand who is the specialist. But I have never asked for the list specifically.
Thank you very much.
Okay, I see another hand raised. So do we want to?
Don Carlos.
Gracias, Gustavo. Well, I have a couple of comments and one question. My comments are, maybe 25 years ago in WIPO, the one who was handling the dispute resolution was Deborah Enix Ross, very well-known lawyer and very well-known for the Mexican arbitration community at that time. That's why we were near the WIPO dispute resolution center in Geneva. We were familiar with the rules, and I remember I read the rules, and they take special care in the protection of secrets and all this stuff. And then I saw that other institutions were following the same path for protecting industrial and commercial secrets and so forth. Second thing that called my attention today is that Rodrigo Acevedo is from Porto Alegre, and in the LCIA, the lawyer who is the counsel who is handling the arbitration in Latin America is also from Porto Alegre, Gustavo Mossi. I didn't know that there were many people involved in arbitration in the world from this small Rio Grande do Sul city.
He used to work with me. A former colleague. Great guy.
The land of the gauchos. But my question is, what is your experience on the arbitration of patent and trademarks registries validity in the world, since in Mexico, a dispute regarding the validity of acts of authority are not arbitrable? I understand that in some other parts of the world they are, but in Mexico, no. I'd like to know your opinion and your experience.
I think it brings to my point on arbitrability. And yes, traditionally this issue of arbitrability is the question of whether the subject matter of the dispute may be resolved through arbitration. Yeah, and it's a very important topic in IP, because sometimes in IP we depend on a public body that grants you the right, such as a trademark or a patent, and we always face the question of if could we arbitrate the recognition of rights, for example, or the validity in the other side, the validity of a patent or a trademark. Usually, those proceedings that are related to validity of intellectual property rights are not considerable, are arbitrable in many places by their specific law and public policy. However, it's broadly accepted that any right of which a party can dispose in the way of a settlement can be arbitrable. So disputes involving a patent may be arbitrated, and there are plenty of disputes in the patent field and trademark. But those disputes will not relate to the validity against any party. It will have effects only between the parties that are on the dispute. Any award rendered will be binding only to the parties involved in the dispute. So this is always a matter of public order. It changes from country to country, but usually we make this connection with the rights in which you can settle. And if you consider that you can, it is arbitrable in IP as well. We have some cases here in Brazil, some interesting cases in the last years about this topic. I think in many places in the world, there are cases related to arbitrability. And more, I see precedents that are accepting the arbitrability. For example, we have a very interesting case in court discussing the arbitrability of a dispute seeking moral damage for an IP violation. And the Brazilian Federal Court of Appeals established that there was no problem at all, that a case such as this one, seeking damages between two private parties, is definitely arbitrable, and there is no public order or no provision in the Brazilian law that would prevent this topic. For sure, it would be different if we would like to request the nullity of a patent with effects to the whole country. It would not be arbitrable. So for this case, you need to go for litigation. I don't know if Angie or Natalia would like to add some comments.
I will be happy to. And Carlos, thank you for this brilliant question. And I understand very well the context, because equally to what you have explained for Mexico, it's same for Russia. Our intellectual property law says that the disputes relating to validity of patents and trademarks are not arbitrable. However, as explained by Rodrigo, it's very different in other countries. And if I speak to their colleagues from Switzerland, I always am amazed that they do deal with patent and trademark infringements and patent and trademark validity in the course of arbitration, which is actually great. The question is whether the dispute is really contractual and you have already the clause, right? Or if it's extra contractual and you have to agree with your counterparty that you want to arbitrate rather than to litigate. I would say it's a rather exceptional situation where you can get the infringer to sign this. More frequently, I would see it for the situation where a conflict has arisen between the business partners, for example, in terms of joint venture, where they, for example, have they are not the same side on how the IP rights have to be allocated between them for some research which has been done. And therefore they turn, or there were patents issued, and one of the parties is trying to bring the issue of validity as a part of dispute relating to conflict about IP rights allocation. So in such a case, of course, it's possible, but all of us, we have to keep in mind that if you want this validity issue to be a part of arbitration, just to clarify the position between the parties, this is one question. The other question is where you want to enforce it in your country. And then, of course, in the countries which do not believe that such disputes are arbitrable, you simply fail in enforcement.
Thank you.
Pleasure.
It's hard for me to see if there are other
Agustin.
hands or chats occurring, so.
Go ahead, Agustin.
Well, yeah, I just, in that context, I just would like to add that it was mentioned at some point, I'm not sure, the author of the article, of their opinion, that maybe at some point, the issue of validity against a trademark or patent might be subject to discussion on an arbitral panel, but the outcome, the result, will be considered like not the to declare null and void the registration of the trademark or patent, but that one party cannot go against the other party, like to oppose the party for using it. So in that context, sometimes this issue is like solved. Not quite sure if that's what your experience is aligned with, but I think at some point is how they are dealing with this issue when two parties into a contractual agreement and then with an arbitration clause, they go like in an issue like in these scenarios, like Natalia was saying, with joint venture or something, and allocating the IP rights, so disputes arise, and they are not going to tell the local IP authority, you have to declare null and void this registration, but more than that, they are going to say to the party, you cannot forbid this party for using it or not using it.
Yeah, just to jump in, I think maybe by a way of summary, although this is, a very important IP issue, this is not necessarily a unique issue. And I want to be sure that we're all, localizing the conflict of law issue, quite honestly, that's happening here. So, arbitration is a voluntary process between two parties who have both signed an agreement that agree to resolve an issue in arbitration. Challenging a filing with a government does not include the government in that agreement. And so the easiest way, if you're fine in some instances, is for the government to recognize arbitration as an appropriate place to challenge a filing or some type of process that is governmental or administrative. And so this is not unique to IP. If I had a challenge in the state of Indiana and said, that's my car, and why can't I file the title because Bob says it's his car, I can't challenge that in arbitration. That has to go to the state of Indiana. It is their process that creates that filing and the recognition of the filing as having a legally significant outcome, right? So I think that's sort of the way, if this conversation has moved beyond you and without knowing, you know, where all the participants are from, I don't know. That's the easy way to think it through. If you're talking about, I'm going to attack the actual process of filing or the recognition of a patent from a state, you have to follow that state's process. And in some instances, they do, some states do recognize arbitration as an appropriate source, but the state gives that power to arbitration. That is not unique to IP. The state gives the power to arbitration to resolve commercial disputes. At any time, quite frankly, any nation state could say, we reject arbitration as an alternative to our courts. You have to come to the courts. That is completely within their power. They won't, and I'm not suggesting that should or is going to happen, but states reserve the power to recognize the process, recognize what's occurred in the process, and recognize the outcome as well. And so that's why you see this variance between the states. Although I will tell you, I'm under the impression, although I certainly haven't done a large global survey, that in general, most states do not recognize arbitrators as being capable of invalidating a filing in car ownership, in title of, of registration of those or IP. Does anyone want to add to that? So, because the conversation went really advanced really fast. So we were told we'd have a very varied audience. So I want to sort of localize it a little more clearly before we leave the topic. Does anyone else want to jump in? Okay, so I don't see any other hands. We did have a couple of other.
Oh, your microphone was okay.
Yeah, I saw it happened. So we did have a couple other questions actually that we had prepared ourselves. And I think one of the questions that again goes back to arbitrability is one issue. But what other difficulties arise when we try to have arbitration as the mechanism for dispute resolution in IP-related disputes? Natalia, do you want to comment first on that?
Yes, and I think we have already covered quite a number of difficulties which the parties may face in the arbitration or before, in preparation to arbitration. So obviously, first of all, that you do have your particular situation covered by the arbitration clause or by the arbitration agreement which you have. Whether the arbitration agreement, arbitration clause is enough, I mean, it covers particularly that situation which happened. And this is not always the case. And this can basically ruin the whole process. Therefore, we always say that it's so tremendously important to make sure that your IP arbitration clause is proper. As I said earlier, to create the arbitration tribunal, it's also a task where, as we have discussed, it's necessary to find for you the best people who can do it. And each of them would traditionally have various approaches in how to handle their disputes. I saw in my experience the arbitrators, for example, for software licenses disputes, who even before we started arbitration were addressing to both parties that actually their preference is to help the parties to settle a dispute and not spend time on the arbitration. So it was not in Russia, it was a different country. And that was the approach. So you can expect this as well, that the arbitrator in an IP dispute would say it's based on the facts, it's much better to settle. So it's a recommendation, but it's also a way forward. What else? Of course, the arbitral awards, as we discussed, are not equal to court decisions. And yes, they are final. there is no chance to appeal. And this is something what, like in commercial arbitration, we have to keep in mind and to consider before starting the arbitration, because are you confident enough in your position? Are you certain that arbitration is the right source, right forum for your dispute? Then the next is, of course, about who is your opponent. What are your options in this particular case? Do you want to keep a good relationship, as in my earlier example about joint venture partners, for example, and you want to use arbitration simply to keep good relationship with the party? I think this is something very, very important for arbitration, and this is a serious benefit which is here, because you cannot expect, unfortunately, in many countries from the state courts and from the judges in the state courts that they would really care that the parties remain best friends, while the arbitral tribunal will be much more inclined to have a nice atmosphere, good discussion, and if this is your goal, I think arbitration is much better for a tax dispute where you have, you have code to write for years after the dispute is resolved. So what else? Already mentioned confidentiality. Yes, of course, very, very, very important, but difficult if it comes to enforcement. And if you know that that will be the case, then of course you have to keep in mind that actually your confidentiality benefit is not really here, because the arbitral award will become a part of proceedings before the state court, and then no confidentiality. Another issue which already has been mentioned by Angie, applicable law. There can be a family of patents or family of trademarks, a big portfolio which is relevant for dispute, and protecting IP rights in different countries. We IP specialists, we know that patent law around the world is the least harmonized branch of intellectual property. And if you have these patents from different countries, you face a real issue where a lot of different laws would be applicable, and you would need experts and specialists. And of course, a very rare case where you can find a dual, triple qualified arbitrator who will be able to cover a big amount of issues, but experts are very, very important. And as I said in the beginning, not such a big amount of great experts in the world these days. Therefore, conflicting them out at the early stage of arbitration is very, very important, that you have the experts to present to the evidence to the arbitral tribunal. I think I covered the most important issues, and I welcome Angie, Rodrigo, and others. It's a great discussion today. It's very, very nice.
Thank you. Yeah, I would like just to add that we already talked about many advantages of having an arbitration in the IP field. I believe that having a single and a neutral procedure is especially a very key point when we have an international licensing scam, for example, and when you need to enforce your rights in several countries under a contractual relation with partners throughout the world. So advantages also in the confidentiality, in the expertise of the arbitrator. We already emphasized it, but I do like to add that arbitration is not for all IP disputes. And this is something that we also should recognize. We already talked about enforceability issues, and there are also some issues related to arbitrability in the field of IP. But sometimes the arbitration proceeding doesn't fit even in the tactical approach that the parties who have. For example, sometimes in IP disputes, when a party would like a precedent-setting judgment, and it is common in huge international disputes on patents that have connections with different countries, and when those precedents are important, definitely arbitration is not the best choice. Actually, parties must agree also to arbitrate, and not always it happens in the IP field. So, so important as to recognize the situations in which that fits perfectly, and in which arbitration helps dealing with IPs, also to admit that sometimes you need to go for litigation.
So I'm going to jump in and ask a question based on that, as long as I don't see any hands go up really quickly. My question is, so when a business or a lawyer advising a business is making this determination, and I'm cheating, so I'm asking a question that I've thought about. You know, how do you recommend they make that decision? Is arbitration the right place for this particular conversation that might, this particular relationship that might result in a dispute, right? That's sort of the easiest way that I try to explain things is, hold on, you can't just, you know, everybody's happy when you're signing that first contract. I'm getting money, I'm selling my product, whatever it is, I'm getting a license, maybe I'm entrepreneurial and suddenly, you know, I'm going to have a massive licensing event. But you always have to think about, what if this relationship doesn't play out the right way? So can you give a couple of examples of things that you might think through, and then how you might add those or think them through in terms of the clause itself? Is that, Roger,
Yeah.
you want to go first because you're still unmuted, so you get called on.
Okay. No, I think one of the issues that may be considered is the complexity of the subject matter. Sometimes we're dealing with very technical issues in IP related to patents, in which maybe to have an expert in the field it would help. The difficulty is that sometimes this is the very last clause that we address when we are negotiating. Yeah, but I think complexity and this need of an expert definitely pushes us to arbitration. Also, the connection with the different markets, with different regions of the world, with different countries, may also suggest that an arbitration clause could be a good choice, because sometimes in IP, we even experiment contradictory decisions, contradictory outcomes from litigation proceedings in different countries. And it's quite hard to explain to the client, especially in IP, because IP is a field of practice that is governed mostly by treaties. We have the Berne Convention for copyright, we have the Paris Convention for industrial property, and all the main rights are provided there, and the countries that are party of those treaties, and mostly everyone in the Occidental world and developed world needs to fit on those requirements. But even though we see a lot of several contradictory decisions in the same subject in different countries, and a way to avoid it maybe is to consider an arbitration clause in which you have just one single neutral procedure. For sure, it opens a debate on where, and again, here is something that WIPO could add, being in Geneva, and usually not the place of any of the parties, and being part of the United Nations organization system may provide a good argument in order to suggest to have a specialized forum in a neutral place, not in the place of the licensor nor of the licensee. I think that another point that was already addressed as something that would push you to go for arbitration is if there are several very confidential and key topics that you cannot reveal in a litigation, or that would be you don't want to open in a litigation proceeding. So I think there are several reasons, but again, I emphasize that it's not for all. It's not for all cases.
Natalia, would you like to comment, or I have a follow-up?
It was covered perfectly by Rodrigo, I guess.
Yeah. So my question goes to sort of the next stage of that conversation, in that standard clauses contain these pretty common phrases of arising under or within. And I'm wondering if in an IP dispute in general, don't be too specific, but in general, if you're recommending for people to understand that not everything that you might naturally anticipate being able to be resolved in arbitration can occur. And if that's the case, do you create some type of multi-tier or multi-alternative clause that says, hey, look, if this has to do with filing, you need to know not gonna go to arbitration. And the reason that I ask that is so it goes back to the arbitrability issue and stuff. The reason I ask that is because the United States has a very interesting, not widely appreciated, and quite frankly, frequently criticized approach to interpretation of arbitration clauses that at times can allow the parties to go to the court to challenge the clause prior to going to arbitration. And so I'm wondering if that particular language might be causing at times issues, and if you'd recommend sort of if you think you have this complex environment, if you create some type of multi-tier, these issues are capable of being resolved in arbitration, but these other ones, we're going to create a clause that says no. And I'm just interested in your comments. I think I know your answers, but can you comment on that? Because that's a very American twist, I know, but it does cause problems. It means you'll end up in the court sometimes to argue about the interpretation of the arbitration clause itself, which is not what most parties would expect. Oh, I should have called on someone. Rodrigo, you're not muting and unmuting, so that means you get to comment first.
No, I think it's a good choice. It's a very local perspective, but it's not only in the US. I sometimes also use different alternative dispute resolution ways as steps that you need to go through. For example, starting with sometimes considering an expert determination or a mediation before going to needing and starting an arbitration proceeding, and as steps to move forward till this final proceeding. I believe this is maybe a good choice. Yeah, what I don't like is when you start to create your own clause. This is something that we deal a lot in our arbitration courses at WIPO, when you try to be very creative and to start adding very specific provisions on the way that the case will be solved later on. Maybe at that point could be a good idea or sound as a good idea, but mostly later on it's better to use the draft that is provided by the center. But for sure this is an alternative.
I think indeed the standard clauses are...
I will mute now.
Okay, so the standard clauses are there so that they're used. They are not simply created for us to learn from and to create our own clauses. But in terms of multi-tiers, I think it really can be helpful if it's not combination of arbitration and litigation, but if we keep the concept of arbitration, which has a prior negotiation stages, or maybe even mediation, but in different levels. For example, first, this is discussion between the parties in the regular managers level. Then it's top managers. If it's a very technical or technology related issue, it would be sometimes the parties, they even create a committee in the agreement, which was something like steering committee, who is in charge of the project and who would consider this case outside of court proceedings or outside of arbitration, and then moving or arbitration depending on the context. I think if this is structured this way, this is perfectly fine and this will function. But to be too experimental can be dangerous, and then there is a case for students why this case has not been accepted by WIPO.
Thank you both. That was exactly what I was going for without, giving everyone the answer. So I wanted to be sure that everyone was aware that there is this opportunity to create this multi-tiered clause that, some of us believe arbitration is the last step. It can feel at times very litigious, and that's not good or bad. It's just the last step. And sometimes you can eliminate disputes early on without having to go through a massively formal process. But the other thing is, and I probably shouldn't share this, they were both too nice. One of the things we do almost every third or fourth year, but definitely within the discussion board, is post a clause where a group of lawyers or business people have been creative in creating these clauses. And they are truly train wrecks. In the United States, you will end up in court while they try to figure out what it was that you were trying to initiate in that dispute resolution clause. And the costs just can go up exponentially because of that. So it's, I think, the entire panel's opinion that in general, regardless of what institution you use, once you make that decision, copy their clause, cut and paste the thing and stick it in there and let it be, because those clauses have been interpreted around the world in general and are, as written, very enforceable when they're incorporated into a contract. I'm aware of time. So I want to give people an opportunity, not that we're completely out of time, but I want to be sure if there are questions that we do respond to any questions that that people have. Otherwise, I do have one final question.
I just have one quick question. You were talking, Natalia, about mediation, and I see my friend Fernando Navarro within the public, who's a specialist in mediation. How often or how common are the mediation proceedings under the WIPO mediation rules compared to arbitration? Are they common in WIPO or not?
Unmute. So WIPO Center, as you know, it's called Arbitration and Mediation Center. And so it's equally capable to handle both mediation and arbitration. It's simply that it's different, right? It's the proceedings are different. The goal is different, and as a mediator, you not always and not necessarily even need a lawyer. You need someone capable to help the parties to find a compromise, to find a solution, and not go to arbitration. This is kind of also, I would say, cost-cutting measure in terms of multi-tier, for example. You do not go to more lengthy proceedings with documents, production of documents, etc., but you stay and resolve the case in mediation. But of course, if mediation is not successful, then you have the situation where you pay for both mediation and then arbitration, which is a sad outcome. But I think every party, the parties usually understand whether the dispute is fit to mediation or not. And my colleagues Rodrigo and Angie will, of course, add their input.
I think you pretty much covered it.
So I have one more question, or we can begin the wrap up. It's up to our hosts.
I think that Darío Oscos wanted to make a comment on arbitrability.
Okay.
I don't know if you want to share that comment.
Okay, thank you very much. Do you hear me? Yes. Well, I would like to make a comment on arbitrability. And as you know, arbitrability is an issue of general arbitration. And when there is a dispute on registration avoidance, whether for trademark or patent, and provided that the avoidance declaration or the avoidance action has to be resolved by the state, and it may not be, therefore, arbitrability under the arbitration of the parties, I will say that there may be some indirect action that may be followed. And what I would like to share is this. What about if the parties agree on arbitration to resolve the dispute, and eventually the award adjudicates that the grounds or the facts lead to the nullity of the registration, whether for a trademark, patent, or whatever IP rights, and you have it. Well, and also within this arbitration scope agreement, the arbitration tribunal may award damages, you know, based upon the consideration or adjudication that the IP rights were wrongly or unlawfully granted. The question is about enforcement, because the Patent and Trademark Office may say, you know, the only with power and authority to declare avoidance is this office, not a tribunal arbitration. Oh, wait a moment, I'm not sure about that. You can do two things perhaps. One is that award may be the best evidence for the Trademark and Patent Office to take into account in a avoidance action if needed. On the other hand, I will say, you know, at least from the Mexican perspective, the Mexican Constitution provides ADRs to settle disputes, all kinds of disputes, any. There is no limitation whatsoever. And I ask myself, and I would like to share with you, if it will be possible in an enforcement action of the award that the patent and trademark recognized and enforce the award, granting and recognizing the voidance of the trademark registration or the patent registration. I think that this issue may be explored. There is no doubt that before this constitutional provision, only the Patent and Trademark Office was with power and authority to adjudicate voidance actions. There is no doubt, and that is worldwide. But now, I will say that it could be possible. We have made this, and we have had some experience in other fields, and it has worked out. And I think that it could be in IP issues, mainly regarding, and I will say, in cross-border disputes, IP cross-border disputes. Let's say that we have the agreement to arbitrate between the parties under the dispute, and the award determines that the grounds of the registration, whether for trademark or a patent or whatever IP rights, is unlawful. And what about if the award commands the defendant to go down to the domestic patent and trademark office and to cancel that registration? The enforcement will be not to the patent and trademark office, but to the defendant. And some kind of these sorts of tactics or strategies may legally be performed and enforced. And with the addition of that, who was found lawfully getting the IP rights may also be awarded for the, I would say, the plaintiff awards. I mean, damages, material and moral damages. And this could be the subject matter of any IP dispute, both industrial or intellectual. We have had some experiences on this file, and we have been successful. Fortunately, we have not had to be forced to go into the patent and trademark office, because defendant, at the end settled. So this is my comment, and I would like to share with you most in the cross-border perspective. Thank you very much.
Thank you for sharing that. I think it's that's an interesting strategy. I will comment. I don't think I, as an arbitrator, would, order something to be invalidated, but it would be I have never even thought about ordering someone to cancel a registration. Rodrigo and Natalia, we are running short of time, I think, but do you have a brief comment to that? But thank you for sharing that. I really hadn't thought that through very well.
Yeah, the same in my case. But I thank you for the very interesting comments. In my experience, the issue is the effect on third parties. And I mentioned a very recent decision from the Brazilian Federal Court of Appeals that emphasized that even discussions on the validity or not of a trademark right or a patent right you can have this kind of debates, and in the decision, the arbitration decision may cover topics like that, but with effects between the parties, not with effects to the right, considering the Patent and Trademark Office and considering any other third party that may be using or wanting to use the same asset. This is my experience.
I absolutely agree with Rodrigo and with you, Angie, and their position. In my experience is that indeed the issue of invalidity, for example, can be brought where the infringement is being discussed. And as an argument for defense of the position, the party says, actually, we wouldn't be able to infringe because this IP right cannot exist due to non-compliance with the for example, patentability criteria or registrability for trademarks. But this is something what would be valid for the parties. So.
Do others have comments on this? This is an issue that Rodrigo, I think, brought up as one of the questions that we had already planned on addressing, but I don't think any of us really realized how robust of conversation this would be. So I don't want to, ignore, I think I've kept up with the chat pretty well, but are there other questions or comments on this issue? Sorry, it takes a second. You've got to give the tech a second. Oh, I was going to say, I think you're still unmuted, so go ahead.
Okay, sorry. Well, I think that we may explore something. Just assume that under these circumstances that we are discussing, one of the relief sought under the arbitration dispute is that if the tribunal found that the grounds for getting the IP rights were unlawful, the arbitral tribunal may adjudicate or grant relief in the terms to bind defendant to abstain to use those rights. But it will not be directed to the Patent and Trademark Office, but to the defendant, to the party that agree upon the arbitration clause and to be bound under the award. And I think that that is possible. There is a great areas within the arbitration to resolve many disputes around all these issues where there is exclusive jurisdiction on the subject matters for the state courts. That is my comment. But of course, that the best to do is to be that the avoidance actions be subject to arbitration. That will be mainly coming from these world institutions that will. Thank you.
I see another hand. So Fernando, I cannot unmute you.
Hi, I'm unmuted.
Oh, there you go.
Good morning, everyone. Thank you for the presentation. And going back to the mediation topic raised by Gustavo, I see that there's a mediation pledge that WIPO has published for IP and technology disputes. And my question is regarding that pledge, has it gotten any traction? I see there's many signatories, but I don't know if that means actual increase of cases and the other linked to that, is there an active promotion on behalf of WIPO for parties and stakeholders to sign the pledge?
I signed the pledge also, and I think it's connected with this goal of promoting innovation and creativity through intellectual property, and to have effective ways to solve disputes or to avoid disputes is part of this goal. Unfortunately, I just signed it. I'm not part of the WIPO crew, and I don't have information on how it's going, and if there any effects that they can already perceive from this initiative. I don't know if Natalia or Engie have any information.
Yeah, I think so. I'll comment really quickly. I think the fact that we don't have a lot of information does suggest there's not a massive effort to promote this. I do also think, however, that mediation is an interesting conversation in the international community right now because of course there is a a real push toward recognizing the outcomes of mediation on a more global environment. Actually very similar to the New York Convention in some areas. And then, of course, a lot of our lives have, it's interesting. Someone asked me, I was on a call last night to prepare for a conversation that we need to have in the next couple of days with APEC about online dispute resolution. And, everyone realized that the world, for at least a lot of us, sort of stopped mid-March, and we all sort of lost momentum and stuff that we had intended to create in particular documents and legal texts that we are working on. So it doesn't surprise me that we haven't seen many push-outs right now in a lot of different areas. So I don't mean that as I guess why I'm saying that is I don't mean that as a criticism of WIPO. I don't think it's their intention not to do this, but I haven't seen a whole lot in terms of widespread dissemination of these conversations and stuff. Natalia, have you had a different experience? I saw you unmuted at the same time I did. So have you had a different experience?
I had, as to promotion of mediation, I think still indeed, as Rodrigo and Angie said, the efforts in this respect, they are fairly limited. It could be much more. As to my experience, I have been a part of mediation process, and since that was in 2020, that was done online, and I think it is something what can be managed online very, very well, because all those tools like Zoom and others, they are very, very helpful. You can see the person, you can see reactions, you can understand whether the person agrees or disagrees, all the mimics and gestures. And yeah, that's helpful. I think there is much more space for promotion of mediation, in fact.
Actually, just before jumping into this meeting, I was participating to other debate on specifically on how to have an efficient mediation through technological platforms such as this one. I'd like just to add a comment on this, that I also agree that both mediation and arbitration may be performed use those tools such as Zoom, and it is a need nowadays, not a choice. I started my speech mentioning that I would prefer to be in Mexico now with you and not from my home, but it is our world nowadays, our normal. But I also believe that there are some concerns and there are some issues that you need to get prepared in order to have an efficient proceeding. For example, in this debate that we had an hour ago, was mentioned, for example, some organizational issues that at the beginning you need to deal with. How if parties are used to the tools, if they know how to perform their duties using all those different platforms. Confidentiality, how to ensure that someone is not recording, or especially in mediation in which you don't use to take record of the conversations, is not a good practice. You cannot do it. How to avoid it really, and especially in mediation, how to create a scenario in which people feel comfortable to open their hearts and to talk about the really reasoning of their positions when we are not together, when it's naturally a more cold, informal environment. But even though it's what we have, and we need to start learning on how to manage it through all those tools that also allow us to have people from Russia, United States, Brazil together with you this morning. Yeah.
So I'd feel really bad if I didn't mention, because online dispute resolution is big in my life, I guess, in terms of developing best practices and stuff. The ICC is one of the leaders in conversations about online dispute resolution. So that is not necessarily, you know, our topic for the day. I'm happy to answer questions, but, you know, I would assume it would be very easy for you to tap into some of those conversations about creating mediation and arbitration environments, negotiation, settlement, mediation, and arbitration environments. The ICC has been a leader in the conversation for a considerable period of time, including cross-border online dispute resolution environments and platforms and the creation of best practices. So I'm happy to continue to answer questions about some of that, but the ICC was actually one of the early participants in creating an environment that would allow that to happen. And I think it stalled a little bit, quite honestly, because of the private sector jumped in and the AAA jumped in fairness, between the two, but they are actually one of the leaders in this area and are always at the various things we do in online dispute resolution, always.
I would like to echo you, Angie, because that's indeed the case, and I think we all recognize the role of ICC generally in development of various initiatives. And one of those which has impressed me in 2019, 2018, and 2020, it's the research on probation of witness evidence. That was really incredible, very, very interesting.
Do we have other questions, or comments, or hand raising? Okay, so I had one final question, and maybe this is that we had talked about ahead of time. So again, I like going back to practical advice in the context of these conversations. So in your opinion, if you are a lawyer who is either crafting an arbitration clause for an IP related dispute, or are you know, facing one that already exists that hopefully, quite frankly, someone copied from the ICC or WIPO or somewhere, how do you think through as a lawyer, or what questions should you think about when considering the enforcement of the outcome? And that's sort of one area that I touched on really briefly at the beginning. It's come up at different times, but from a strategic standpoint, this is a massive issue. So maybe if you can give just a couple of how do I, you know, I've got the clause, what's the next step for me to think about so that I ensure whatever it is that we do is enforceable? How do I think through making that happen? Natalia, I'm going to call on you first.
Yes, thank you very much. Great energy. Yes, I think it's simply as a practitioner, you have to focus first on the jurisdictions where you want to enforce it. What are the key jurisdictions to be covered, and what are difficulties in those jurisdictions? And you, starting from there, you understand where the whole arbitration process will bring you, or maybe the most important market for you cannot be covered by the arbitration award in which you would invest your money, and therefore maybe you should consider simultaneously additional proceedings. So I think that is the very, very, very important, because otherwise the role of arbitration is diminished, and it's not good for promotion of arbitration. Rodrigo?
Yeah, I would just emphasize to rely on standard clause and on service providers that are well established, such as the ICC. And if you need something very specific, if your dispute is has as the main subject matter IP assets, consider WIPO maybe, but don't try to invent too much. Rely on solutions that were already, service providers that were already tested, and on clauses that were previously written in the way to help you to enforce. For sure, you need to take care also of the way that the proceeding is performed in order to check if all those requirements, very basic requirements of the New York Convention, were complied. But if you rely in a service provider with the tradition of ICC or WIPO, you can be very confident that you pretty much can enforce it as you need.
I had one other comment, just mostly because mediation has come up multiple times, and another sort of tool that we now have in some places is the capability of enforcing mediation through the Singapore Convention. So it's not, and it's not as global as the New York Convention, and it's not as well tested. Obviously, we're looking at, it came into force in September of 2020-ish, I want to say. So we're coming up on when it's actually going to really kick off. But it is something you should think about, right? The group of us have suggested to you that mediation, or a settlement that produces what they're going to call a mediated outcome, very quickly will be enforceable in, I think it's 23 states. If someone remembers, give me a heads up. But so, and that is an interesting conversation, and it adds just to the opportunities that you might want to consider. And there is nothing to necessarily suggest that if you have an arbitration clause, that the parties on the day when the dispute happens couldn't agree to mediate, right? So, I mean, that's sort of the ICC's way to come into traditional arbitration. The parties on the day create an up-to-date arbitration agreement that does, in fact, create a level of specificity for how you'll behave. It's one of the things that I always found incredibly forward-thinking by the ICC, is that you sit down in that sort of stage one. So, in general. So that's an interesting conversation of how that changes almost every answer that we've given you today, with mediated outcomes being able to be enforceable a lot of places. So that was the other thing I was thinking through as I asked that question, is it will be interesting to see from an academic standpoint, if you have a country that signed on to the Singapore Convention, but not the New York Convention. Now you're better off to go to mediation because your award might, so this could create an interesting, now one could assume that's not going to happen because, first of all, there are very few countries that haven't signed the New York Convention, but in theory it could happen, or there could be a lag between, a country pushing through the New York Convention but has, participated in the drafting of the Singapore Convention and signed it at its opening. So this is an interesting time in thinking these things through. And I do think it's something that we should think about as well, because it does change enforceability drastically, in my opinion. Since I added that, Rodrigo and Natalia, do you want to add to that? We don't actually usually talk about the Singapore Convention in general, and mediation is not within my expertise by any, so I'm not suggesting to you I'm an expert in the Singapore Convention. But do either of you have, I hate to put you on the spot because we do arbitration for the most part. Do either of you have comment on that before or do
no, I, as you mentioned that it is the final remark, I just would like to say thank you for inviting me to participate in this very interesting debate. And I hope you keep safe.
And I also would like to add that it was very, very nice to have such a lively discussion with questions and comments. And it's, as it was said in the beginning by Alejandra, it's a miracle. So we are very, very happy to be a part of a miracle.
I agree. Thank you very much. Thank you for the invite. And, you know, as I said during part of the conversation, for an international commercial lawyer to be invited to speak at an ICC event is, you know, I could have never envisioned that when I was first learning about the ICC as an institution and its influence on international trade and international commercial law and international dispute resolution. So I think I speak on behalf of all three of us for saying thank you for giving us this opportunity. I hope you enjoyed it as much as we did today. And with that, I'm going to turn it back over to our hosts.
Okay, well, I think we're really thankful for all your contributions. And I think it was really interesting how you conducted the whole session. It was a wide overview, but short with interesting content, and give us a lot of things to keep searching and studying for the future. So really, really interesting. I'm really, really thankful to your participation with us. So Gustavo, some final remarks?
Yes, thank you, Agustin. Angie, Natalia, Rodrigo, thank you very much for sharing your knowledge with us. It was a real privilege. And I hope that someday soon we can have another session in which we can meet personally. For you will always be welcome in Mexico, especially in Guadalajara, the land of tequila and mariachi. Before saying goodbye, we want to invite you all to our next session, which will be held online also on October the 8th. We will be honored by Gabriela Alvarez, partner in Curtis and one of the leading professionals in investment arbitration proceedings. She will talk about the changes regarding the standards of protection of foreign investments introduced by the new United States-Mexico-Canada Agreement in contrast to NAFTA. So we will be really happy to see you all again in October. Finally, I want to thank Laura Altamirano and Abigail Blanco and all the ICC Mexico staff for making this possible. Thank you all for being with us, and see you next time.
Thank you very much. Bye-bye.
Thank you.
Thank you.
Bye-bye.
Thank you. Bye.
Thanks a lot, and bye-bye.
Thank you. Bye.
Thank you very much. Congratulations.